name is Mokua Manyara. I'm the chair of the Young Lawyers Committee of the East African Law Society and a co-moderator for today's webinar. The topic of the webinar is the dawn of a new era, exploring opportunities in digital arbitration and online dispute resolution. This comes at a time where we have witnessed, especially in Eastern Africa and Africa, there is increased proliferation of technological tools to increase access to justice and dispute resolution amongst the key stakeholders, including the lawyers. So the topic of today is aimed at harnessing the available tools and the best ways for the young lawyer to harness these critical yet very, very important and available tools to increase to allow them to practice law and online dispute resolution mechanisms in a manner that allows them to exposes them to better opportunities in the practice of law. So I would also take this opportunity to briefly explain the history of the East African Law Society for the purposes of the membership, to appreciate our origin, where we are and where we are going. So therefore, it is my humble honor to say that the East African Law Society is the apex regional organization of the bar associations, which was jointly founded in 1995 by a group of lawyers with the support of the leadership of the national bar associations of the member states. Currently, the membership stretches to over 35,000 lawyers and comprises of all the national bars in the East African community. That is the Law Society of Kenya, the Tanganyika Law Society, the Uganda Law Society, Zanzibar Law Society, Rwanda, Burundi, South Sudan Bar Society, and recently we have the DRC joining our membership. We hope soon we'll have Somalia joining our membership as well. The membership is both institutional and individual. That means by virtue of being a member of your bar association, you're a member of the East African Law Society. But then there are subscribed members, the individual subscribed members of the society. That said, we go to the next part of our webinar, that is panel speakers' presentations, which each will take 5 minutes to tell us what they know about the topic and about themselves. In that regard, I'd like to invite the Vice Chair of the Young Lawyers Committee, Agatha Ninsima, to introduce the first speaker, who will give us her brief remarks. Agatha Ninsima, to introduce the first speaker, who will give us her brief remarks.
Thank you so much, Mokua, and our dear young lawyers that are logged in on Facebook, those that are logged in on YouTube, and those here at this Zoom meeting. Good afternoon, everyone. Thank you so much for joining in. Today, we are privileged to be joined by a panel of experts in the topic. And I will just make the first introduction. Our speaker, Rita Nakalema, is here with us. Rita Nakalema is a senior associate at Engoro Muchebi Advocates in Kampala, Uganda. She's a practice head for risk compliance and governance. She has an LLM from Queen Mary University of London in international business law. And she has several certifications in arbitration and alternative dispute resolution. Ladies and gentlemen, join me to welcome Rita Nakalema. Rita, you're welcome. Please, you can unmute and say hello to our attendees for today, and also make brief introductory remarks on the topic that we have today. Over to you, Rita.
Hello, everyone. Good evening. Good afternoon to you.
We can't hear you though, Rita. Some volume.
Hi, Agatha, can you hear me now?
I can hear you, Rita. I can hear you.
Yes, I can hear you. You're breaking a bit, but I can hear you now.
All right, good afternoon, everyone. I am very happy and privileged to be hosted this afternoon. I'm looking forward to the discussion. This is something we cannot run away from. Technology has totally reshaped the way we socialize, the way we do business, the way we interact with each other on both the domestic and the international level. So it is ultimately it had to have an impact on dispute resolution. And accordingly, as soon as we harness all the technology that we have and see how to merge it in our dispute resolution practices, then we will be able to achieve very many goals, including access to justice. Technology is key. It is here to stay. It's not going away. We are not going backwards. We are going forward. So I'm looking forward to having a discussion on its impact on dispute resolution processes and how to make it better, what kind of technology tools are available already on the market for young lawyers to use as they practice law and as they participate in arbitration and alternative dispute resolution. I am looking forward to learning from the other panelists that are present here. And I also look forward to the interaction we'll have with the other members that have logged on. Thank you very much.
Thank you so much, Rita, for those brief introductory remarks. Our other panelist is also already online, Eunice Lumalas. Welcome, Eunice. We are glad to have you today. Just a brief introductory, brief resume for Eunice. Eunice is a trial advocate, practicing arbitrator and mediator, accredited by the Mediation Accreditation Center, MSC. She's an international arbitrator fellow and mediator. She's Kenya's representative at the International Center for Settlement of International Disputes, ICSID, Washington, D.C. She's a member of several alternative dispute resolution centers, and to highlight, she's a qualified patent agent as well, a commissioner for oaths and the notary public, and the founding member and chairperson of the Women in Alternative Dispute Resolution. And she has been recognized for her legal excellency and her various contributions in ADR practice by the Law Society of Kenya. Eunice, we are very honored today to have you. And please, you can unmute yourself and make your introductory remarks and your general overview on the topic at hand. Thank you, Eunice. You're welcome.
Thank you very much. I'm very pleased to be here. Brenna, Agatha, Mokua, Manyara, I hope I'm clear. Greetings from Nairobi, Kenya, and welcome to the webinar. I am honored to discuss opportunities in digital arbitration and online dispute resolution. And this is an East African community initiative. So congratulations for this, because when you're talking about opportunities in digital arbitration, I believe there should be nothing stopping us from having arbitrations among ourselves as East Africans. What am I saying is that those opportunities in arbitration that are present in I was just sharing with one of us how in the year 2018, 2019, I spent quite a bit of time in Kigali because of the growth of arbitration. And thankfully, we have arbitration centers here. In Kenya, we have the Nairobi Center for International Arbitration. In Kigali, we have the Kigali International Arbitration Center. And those were very good learning grounds and teaching grounds for arbitration for young people and international arbitration for some of us. So what am I saying? 2020, in terms of arbitration, we saw change. A lot has happened in the past 10, 15 years, but for us, particularly speaking from the Kenya jurisdiction, which is mine, we saw a lot of use of digital effects that COVID had on us. I lost my mom due to COVID and other underlying conditions. However, we must give credit where it's due. During this pandemic, we had, as human beings, to find a way to survive. That means that we had to adapt as fast as we could to how to resolve disputes, because we profit, or our business is in resolving disputes. That's where we earn a living. And 2020 onwards saw a rise in now proper online dispute resolution. And with that came rules. You see, we had, like, the Chartered Institute of Arbitrators had to come up as our other arbitration centers with rules with which to govern and manage parties and the arbitrator when they're resolving disputes online. I'm not sure I need to talk about arbitration much. I want to encourage all of you to get to know what arbitration is. But basically, in arbitration, a third-party neutral is empowered, mandated by law and parties' agreement to resolve parties' disputes and to give a final and binding, we call it an arbitral award. So you listen to a dispute, and unlike mediation, you have the mandate from the parties and from the rules that they choose to render a binding decision. And that way you are guided by whatever rules that parties choose. I think we'll talk about a little bit more about that later. In terms of how we have seen that rise in digitization, let me just, it's introduction, but let me just give an example of this morning. I was before a magistrate, and it was a convoluted matter. But because online, we in Kenya, judgments and rulings and directions are equally issued online. So in the matter I was involved in this morning, one of the parties actually failed to serve my client. And evidence of service is normally an affidavit of service. So it was missing online. And because of that, and the system, it's very clear under the rules that you need to file affidavit of service online unless there is an outage or other circumstance preventing you, and you have to demonstrate that. Because there was no demonstration as to why an affidavit of service was not filed on the online platform. In Kenya, it's called CTS. I don't know if this is a practice elsewhere. Then I was able to vindicate my client, and it was obvious and clear that a rule was breached simply because of the online system. So with the rise of digitization and online dispute resolution, then we see we have to move with the times. We have to think of the evolving legal framework, and we'll have to answer the question. I think during this webinar, we must answer the question as to whether we are moving as fast as the digital and technology era, or the technology is moving faster than us, so much so that the legal space may shrink if we don't move with the necessary speed to ring-fence that profession, what is known as the legal profession, and the job of dispute resolvers in general. Thank you very much. That's what I will say by way of introduction.
Thank you so much, Eunice, for that elaborate and yet insightful introductory remark. Our other panelist has joined us, Mr. Oche Milton Fred, you're most welcome. You joined when we are at the point of making introductory remarks. Basically, we are looking at what you understand, your understanding of digital arbitration or online dispute resolution. And over to you, Mr. Ochen. Maybe briefly before I can just point out a few things from his CV. Mr. Milton is an advocate from Uganda. Just a minute. Over to you, Milton. I will get to your resume and point out a few things from there as we move on.
Thank you, Agatha. Can you hear me? Hello, Agatha, can you hear me? Can you hear me?
Can you hear me?
Yes, we can.
All right, thank you. Technology sometimes has its glitches.
Yes, we can hear you. Yes, we
All
can
right.
hear you now.
Okay, thank you for this opportunity. I thank the organizers. Digital, in one way or another, each one of us has experienced some form of a digital application. I believe emails have been exchanged, that forms part of digital. So in simple language, what we are discussing here today is being able to handle an arbitration process, or stakeholders in an arbitration process being able to communicate and proceed virtually in space through use of tools and devices like computers and what and so on. Allow me say this at this point in time, that what we're talking about is the interaction between technology and arbitration. My sister already explained, briefly defined what arbitration is. Basically, parties resolving their disputes by use of a private person who is knowledgeable in the subject of dispute, as opposed and distinguishable from the national courts, where by default, if you have a dispute with person X, the matter goes to the courts will allocate their system. So the arbitration is where parties privately agree that instead of going to the courts, can we please go through arbitration and therefore have a private person who is called an arbitrator handle this dispute for us. I specialize in construction law. By default, almost every dispute resolution clause of a construction contract is resolution of disputes by way of arbitration. Sometimes it's multi-tiered. It starts from adjudication, goes to arbitration, and so on. So that is in brief what arbitration is. I just wanted to add that. So allow me say that. So it's an interaction between technology and arbitration. Allow me say that is not something of the future. It is happening now. My sister just gave an example. Last year, about the same time, I was conducting a virtual, a digital arbitration, or you may call it online dispute resolution, with the London Court of International Arbitration, seated right here where I'm sitting now. The tribunal was in London. Witnesses scattered all over the world. So basically, digital arbitration comes from a backdrop that we want to ease the procedural efficiency of hearing a matter by leveraging on technology that we have. You don't have to travel or fly all the way to London or Paris. From the comfort of where you are, the parties involved, you're able to handle that dispute. Of course, there are some concerns, as we shall dive later on and see. Traditionally, the rules of arbitration are designed for physical presence. You will note that there are references to a particular sitting, which is private and confidential. So what digital arbitration does, it's trying to leverage on technology to be able to minimize costs and time, procedural efficiency for that particular matter. So that is the animal that we are talking about in as far as digital arbitration is concerned. Being a practitioner in Uganda, just allow me just talk a little bit about the domestic. We will go on into the international space given opportunity. So the primary law in Uganda is the Arbitration and Conciliation Act. I believe it is similar to what we have with our brothers and sisters in Kenya. It is modeled on the ancestral model law. So in that act, we have, for example, under sections 3, subsection 3, I think B, which defines the form of an arbitration agreement to include correspondences, for example, email exchanges or any other means of communication in writing that has a record to be determined as an arbitration agreement. So from that point on, you see that our laws domestically allow for digital arbitration, or what you may simply call virtual hearings. COVID acted as a catalyst for digital arbitration, domestically here, internationally, regionally, all through, because people were grounded and disputes had to be resolved. Arbitral institutions locally, for example, ICAMEC, and internationally, the LCIA, and all those, they rushed to include in their arbitration rules, the inclusion of the use of virtual hearings. All those institutions, the ICC, the LCIA, including CIAB, where most of us are members, which is the Chartered Institute of Arbitrators, UK. So we've seen that trend at that global level. We've seen that trend at a local level. Also, at a continental level, we have seen the there's what is called the African. It's the African protocol. It does provide for. It makes at a global level. Sorry, at the continental level of Africa, it does provide for. These virtual hearings. Actually, the Africa Arbitration Academy Protocol on virtual hearings. You have the guideline notes on possible measures by the ICC. You may call them ICC guidelines. Notable also at international level is the Seoul Protocol on video conferencing international arbitrations. The Americans with their AAA, which is the American Arbitration Association, also came up with their own guidelines. The LCIA, the arbitration I referred to, we are participating in the LCI arbitration. And all these were brought up to be able to accommodate and ensure that the arbitral principles were complied with or are complied with in the digital space. So also locally, for the benefit of my brothers and sisters who don't practice in Uganda, we do have the Constitution, in brackets, integration of ICT into adjudication process of courts of law. It's a practice direction which came in 2019 here in Uganda. So that enabled or facilitated more the use of digital arbitration in our spaces of practice in Uganda. We also have notably the Electronic Transactions Act, which allows electronic transactions. So we have institutions I've mentioned, CADA, we have ICAMEC, and also lastly, let me point out the aspect of the courts, because the courts are very important as well, the attitude of courts. Recently, we had a decision from the commercial court, which actually allowed, I think it was Justice Patricia Kahiji, allowed chats on a WhatsApp to constitute an agreement. So that's the attitude of courts. Before that, around 2021, there was an arbitral award that was rendered in South Africa and was brought for registration for purposes of recognition and enforcement in Uganda. And one of the grounds that the other party was relying on to try and challenge that process was the fact that they were not given opportunity to participate in that arbitration because the arbitration was in South Africa. So the court, among other reasons, rejected that and said no. There was opportunity. Notifications were sent electronically. For now, let me stop here. Thank you. Agatha?
Thank you, Mr. Chen, for that elaborate introductory remark.
Agatha?
Thank you, Mr. Chen, for that. Just
Welcome.
maybe to a brief addition to Mr. Chen's CV. He has over 15 years.
Welcome.
Over 15 years extensive experience in construction law and arbitration. And once again, we are privileged to have you with us. We've had that, and maybe there are some young lawyers on this call who have not even participated in the traditional arbitration. And our panelists, you're talking about digital arbitration and online dispute resolution. And I would like us to look at the specific jurisdictions. And I want to go over to Eunice. Eunice from Kenya. Maybe you can, please, you have a dual experience both from Kenya and Kigali. Could you kindly just educate us about the difference between this online dispute resolution in comparison to traditional arbitration, and give us the different jurisdiction experiences that you've had. How is it done in Kenya? How is it done in Kigali? And what can we pick from the different jurisdictions you've practiced in?
Okay, thank you very much. I wasn't expecting. I was listening, so I wasn't expecting to be called out. But anyway,
Thank you very much.
What I can say is that the beauty about arbitration, and I want to urge that after this session, as many of us as possible get an interest in arbitration, is that arbitration does not know any borders. Arbitration is not restricted to a nation. And that once you understand how the process is, and it is in your area. For example, we've had Mr. Milton say he is, and sorry, I'm not sure whether it's Mr. Doctor or Professor yet, so you forgive me for that. We've had him talk about his interest and practice in construction arbitration, all right? So if you are handling construction dispute resolution and arbitration in particular, that means that if you understand the process of arbitration and disputants are before you, then they choose rules that they wish to be bound with. And those are called procedural rules, which will be the rules that are used in the process. I hope I'm clear. So that I can be in Kenya and I could have a dispute with a company in Uganda, and we decide to use the United Nations Commission on International Trade Law. Normally, you'll hear it, as UNCITRAL rules, or we can even choose the Nairobi Center for International Arbitration rules. You'll find them online. There are 2015 rules currently under review. We can even choose that we now want to use the rules from Uganda or from Kigali. That is okay. Those rules will guide the procedure all the time. So it won't matter the country, and parties are free to choose the rules irrespective of where they are. So basically, when we choose to apply to apply information and communication technology, or ICT, to our practices of dispute resolution, ICT in dispute resolution, that's where we call it ODR, or online dispute resolution. Traditionally, we have enjoyed a lot of travel before COVID because we have always had to travel wherever we are needed for a dispute resolution. And oftentimes you find that in some arbitrations, for example, international arbitrations, they spring out of agreements. So normally parties will stay in an agreement for this dispute. If it arises, we wish that it will be resolved via arbitration, and that we choose to have the arbitration resolved in London. That is the we choose London as the seat, and I really don't think we want to talk about terms like seat, but we choose to be bound by the procedural rules of London, and we choose London as a seat. When you look at most African countries, just to give a comparative review because I was asked, one of our major difficulties, and I think I want to add that wherever we are, we break this, is the fact that we have chosen external nations. Sometimes there was the opportunity to travel and everything. We need to resolve our disputes, even Africa, to resolve our disputes. And we all, just allow me to say this, that in online dispute resolution, because only we sit, an arbitrator is before documents, and sometimes it's bundles and bundles of documents that we have, and other times witnesses are there. So when we move this online, we have dispensed with all that. What will guide us are the rules on how to resolve those disputes under a virtual platform. And often you will find that messaging can be used to resolve the disputes. WhatsApp, emails can institute the disputes, and it can finally end up at virtual platforms such as we are on right now. Finally, and I don't know how many minutes I've used, but finally, allow me to just start off by saying, to reintroduce the fact that most of the online disputes, and I want to encourage all of us to get interested in those kind of disputes, are as a result of the rise of retail business online. You see, like eBay, which are the others? We have Alibaba and such platforms where the disputes arising out of online sales. Earlier, when I was looking at the research, last year it was at over 60 million disputes being resolved online. Some of them by intervention of third-party neutrons, others it's just through online communication. You clarify, you settle it, and there's no intervention of a third party. Neutral can negotiate and resolve a dispute actually without having any party intervene at all. So maybe I can stop there and allow the next question. Thank you. The next question. Thank you.
Okay. Thank you so much, Eunice, for that informative response. And panelists, if you want to add on any of the what she said, when the opportunity comes, you can please chip in and add to what has been said. But I just wanted to go over to Rita. Rita, we see that you are an African Young Arbitrator and an LCIA London Young Arbitrator member. Just to pick from your experience, Rita, what specific technological tools or platforms would you recommend to fellow young lawyers who are interested in incorporating technology into their practice?
Thank you, Agatha.
Over to you, Rita.
Thank you so much, Agatha. That's a good question. Before I delve into the technological tools to use, I just wanted to add something small to what Eunice had said, because I understand there may be some young lawyers online here that would really want to know what this online dispute resolution thing is all about. A lot is going to be said about digital arbitration. But I think this is an area for those people that are interested in tech that should dig deeper a little bit into that. ODR is not online ADR. There is a confusion that may arise when you think it's basically using online platforms for ADR. Like Eunice said, you use other technologies to resolve your disputes. Now, in some of the other developed countries, they have actually come up with platforms that are specific for ODR, you know, and the parties will negotiate their own. They can even appoint a mediator, and at a later stage, maybe I'll be able to share some of that information to help some of the members who are attending to better understand that whole concept of ODR. I just wanted to make it clear that ODR is not online ADR. It's a different dispute resolution mechanism. So at this point, I could say we have three. We have the litigation. You could go to court and adjudicate over a matter. Then we have arbitration and negotiation, mediation. All those fall under ADR. And then now there's an emerging trend on ODR. Now, in order to answer my question, where do you start? What are some of the technological tools or platforms that you can use? These are quite, they're already here. You know, some of these things, they started during COVID. That's when most people, most businesses realize that they can continue to exist even when there's no physical interaction. So as a practitioner, you have to, you probably have met some of them. The simplest is probably Zoom. I mean, we are here using technology right now to learn about dispute resolution. You can use Zoom when you go for an arbitration, as long as the parties agree to that. You can use Microsoft Teams, you can use Google Meet, because the functionality of those, starting with the period of COVID, it has shown that if you have a steady flow of internet, you'll be able to attend a meeting or conduct a hearing and get to the conclusion of it. However, now the other tools that a practitioner who's interested in technology, that the other tools they would want to use is they would want to first delve deeper. What sort of technology do I want? There's different types of technology. It's very broad, but for your practice, if you're going to do arbitration, if you want to use it in litigation, what particular technology tools do I want? Then these, you break them down into case management systems, document management systems, and they're already being applied in arbitration hearings and other dispute resolution practices. Now, for example, on case management systems, there's various softwares. Some are free, some are for paying for, that you could use and incorporate into the practice. Some are domestic, local. Even in Uganda, we have people that have already set up software that you could use in that. And then some are international. So there's things like Clio or MyCase or, you know, arbitration intelligence, or in Uganda, we have a system called Case Management Uganda. You could find a way to incorporate that into your proceedings, into your arbitration proceedings. It will help to, you know, to help you to prepare your documents and see what's relevant, what's not. And in some circumstances, for example, if you're working on a cross-border transaction and this matter has over 7 countries, 9, 13, there's people in Singapore, Japan. Some of these systems, you may not know about them, but you would learn about them if you are working on a cross-border matter, and the other teams in other international firms or other places would be able to share different systems and create platforms for you to use. The other tool would be under document management. We are seeing a rise in the creation of different virtual data rooms, because now if an arbitration is, it contains huge huge documents, and you cannot even share that just on email. If you can't share a link, you would need to create a virtual data room. So you need to look into that as well. And some people use here in Uganda, we use Dropbox or Anserada, iManage. There are very many systems out there and tools or platforms that you could use to incorporate into your arbitration or dispute resolution hearings. So yeah, basically that's that. Thank you so much.
Thank you, Rita. You've mentioned so many tools, and really some are new even to me. So I was wondering where young lawyers can get this information. If I'm looking at case management systems, you've talked of Clio, you've talked of My Case, and also the many document management systems. How this is just a follow-up question. How can a young lawyer have access to these platforms? Is there a place where is there like a database for them, or I just need to reach out to you, Rita, for you to recommend some?
Yeah, Agatha, I'm happy to clarify on that. So because we're using technology and it keeps advancing, finding out about these tools and these platforms, it's as simple as clicking away. You just have to search for a case management system, and you'll be able to see that they'll bring you a list, obviously, if you Google them, for some that are free online and some that are paid for. Personally, I've had an opportunity to work with other, firms in other jurisdictions. So I know about some of these because they've been incorporated in some of the work that I do, but I know for a fact that they are here in the market and lawyers are using them, they're digitizing, they're becoming more efficient, and they're doing better work because of that. Even though I think maybe Milton will hint on that, most of our arbitration centers here in Uganda, I know that ICAMEC has an online system, a specific case management system that you could use. So some arbitration centers have already inbuilt systems, but if it's an arbitration and you've agreed on a third party to arbitrate and you don't have a system, it's still up to the parties to decide and agree what system do they think is affordable, available to them, would be best incorporated into their matter, to see how to get to the root of the issue and to resolve the conflict. But things like the data rooms, so they're also available. I mean, Dropbox is there and Google, and these are things that you can easily come by, and I'm happy to share slides later on so some people can click on that. But things like the data room, so I mean, Dropbox is there and Google, and it's
Okay, thank you, Rita, for that. In case anyone is interested, Rita has pledged to share some of that information with us. Our dear attendees, once again, I just want to remind us that we are live on Facebook, and in case you have a question or you want to make any suggestion, please use the Q&A section, or you can use the chat, the Q&A section, and we shall pick up all your questions there. Just to build on to what Rita has said about the different tools that are available for us to use, Mr. Ochen, I've seen you have extensive experience, 15 years really, in construction law and arbitration. We know that technology comes with issues of data protection and privacy. Maybe my question to you, Mr. Ochen, is how safe is this ODR? I know that in construction law, issues of data protection are so important. How is this digital arbitration or the online dispute resolution? How safe is it for for dispute resolution? How sure are those systems, these case management systems, these document management systems that Rita has talked about? How safe is the information? Or what are the ethical considerations in respect to this particular online dispute resolution?
Thank you, Rita. The safety, one, it will be based on the choice of the tools that you decide to use as parties. My colleague Rita has mentioned quite a number of them, but you will realize that as you, depending on the nature of the arbitration, is it institutional or it is ad hoc arbitration? By that I mean, is the arbitration being done under a particular institution? I've found with my interaction that most times the institutional arbitration offer more protection in as far as those tools are concerned. The arbitration that I referred to, there's a system called IDRC that is a provider to London Court of International Arbitration. So it depends on the level of investment that is made into that system for purposes of protection. I did say earlier on that one of the cardinal principles of arbitration is the confidentiality, that this information that is being shared should remain confidential. So you ask a very, very relevant question. Of course, there are laws also to guide and provide for data protection. Locally and internationally, we do have the data protection laws. Virtual or ODR, let me say ODR, issues of data privacy and cybersecurity are very, very important. That parties must be able to safeguard. So in other words, the safety to me depends on what application you choose to use. But also parties must sign up to that confidentiality, that they do not leak out information. Arbitration is largely driven on party autonomy. As arbitrators, it is important that in the process of utilizing these tools, because it could be improvising and saying, okay, the parties agree. So you must make sure that under the party undertakings, parties make those commitments to one another by way of a party agreement to comply with certain things. And among those includes, upholding the principle of confidentiality. And it's also important that as an arbitrator, for example, when you're handling an arbitration, you ensure that a particular arbitration room does not have third parties. That certification has to be done. Again, I go back to the experience that most times these institutional arbitrations provide that safety by investing in high-end technology that has data protection, cybersecurity, firewalls, to be able to take care of this risk. Thank you.
Thank you so much, Mr. Milton, for that. Yeah, really, data protection is key for any dispute. Really, you don't want documents. We see so many unethical practices. Someone has filed a document; it's not yet even in the public domain, but it's flying all over on WhatsApp, and to confidentiality. Let's go to Eunice. You raised an issue in your introduction about whether we are moving as fast as technology as a legal profession. Are we prepared for this online dispute resolution? Do we have what is required for us to practice in digital arbitration? And as you come to answer that, I just also wanted to add, what can young lawyers take into consider, like what opportunities exist for us as young lawyers who would like to participate in online dispute resolution, but maybe we are not sure, or we would like some mentorship, or we really want to pursue it, but we don't know where to start. Over to you, Eunice. How fast are we moving as a legal profession?
Okay, thank you so much. I wish to start by saying that the digital platform has opened up this space for a lot of people, including young people. That means as we speak, I think a lot of times it just requires courage. Now, when you look at online business right now, and there's quite a number of business platforms, you know, the ones that we know internationally are there. In Kenya, we have some, but internationally, we know of Amazon. We know that now you can buy things from anywhere in the world and they will be delivered at your doorstep. Dispute resolution, and sometimes we just need to organize ourselves. Once we have started our own practices, we can approach some of these big retailers with proposals to resolve their disputes online. So allow me to just, I needed to say this. Either in terms of arbitration, as Milton has said, it could be an arbitration that is managed through an institution. For example, London Court of International Arbitration, or the Nairobi Center, for example. And I believe that, just to go back briefly on the issue of cybersecurity, we need to invest in cybersecurity as we are resolving disputes online, because there could be attacks, there could be hacking. We cannot prevent all this, but as long as you can show that you at least put in place minimum requirements as to protect the information and data of clients. And also, I'm sure a lot of our jurisdictions now have data protection laws, and we adhere to that, because there was a question about ethical considerations. Then where a breach has occurred, and trust me, as an arbitrator, you can be sued if it is found that you are malicious or negligent, depending with how the Arbitration Act or rule provides, outside of the separation of immunity. Then it's better that you invest in cyber protection to stop that hacking. And I think a lot of that has been said. Now, in terms of opportunities, to look at the question and mentorship, several organizations, once you decide you want to be an arbitrator and where do you want to do the arbitration or to learn the arbitration from, we all know that you don't need to be qualified as such to be an arbitrator. Parties can choose in the agreement whom they wish to be arbitrator. You could be a person with 1 year experience, but parties can come to you and choose you, Agatha, as an arbitrator. Would you say, no, I don't want to be an arbitrator? No, that what we are encouraging every young practitioner to do is, even though you can be chosen, for you to be an effective arbitrator, because in dispute resolution that is outside of court, and I believe in court as well, your name is very important. Your name is what is going to sell you. And if you're known as a person who is expeditious, who is a person of integrity, who takes your work diligently, then that is the kind of arbitrator that people will be coming to. And now also let me talk about competence. You don't need all those certificates to be appointed as an arbitrator, but how will you effectively handle your arbitration if you don't have those skills that you are required to have? I'm very proud of Madam Rita. She has studied all the way to Queen Mary, which is helping a lot in terms of expanding commercial arbitration knowledge. And therefore, I'm urging you to find an institution. Start with certificate courses. Learn how is arbitration, how can it be effective. Attend meetings, attend conferences, network with those in the industry. Serve, offer to serve, even for free. You can ask me, Eunice, do you have an arbitration? And I've been asked before, so that I can sit in and learn. How do we, as even myself as an African arbitrator, if I want to learn about the civil law jurisdiction, and these interactions may have made me network with people practicing in France, for example, I would request them to allow me to sit in their arbitration to gain the experience. I'm urging you, young people, to reach out. Do you have an arbitration? Is it in Kenya? Who are the parties? Can I sit in and learn and actually be serious about learning and follow up with the seniors, and you will get to learn how it is. And there are many opportunities in arbitration, because no matter the disadvantages in arbitration, because people have complained, oh, sometimes they take long and we have some corrupt arbitrators, whatever it is. The thing is, in some commercial disputes, and you've heard Mr. Milton talk about construction disputes with arbitration clauses, it is very difficult to do away with arbitration because there's no better alternative. It still offers the most effective alternative to resolve disputes most effectively. And now, because of ODR, we can file documents, we can use chats, even live chats. Have you gone online some places where a chat box can come in and say, hi, how can I help you? You answer back. All those systems are opportunities to invest. Now, there's a large network of people that has now arisen in this field. You find program managers, you find people developing apps to use for online dispute resolution, program managers. I would encourage lawyers to open their eyes to also app development. What apps can be used to make it effective for people to resolve maybe commercial disputes online more effectively? Those are areas that we can look at. I think my 5 minutes is over. I can stop there.
Thank you, Eunice. Your 5 minutes are over. I'm just going to add you 1 minute to answer the part of whether we are moving as fast as technology.
Oh,
as,
thank you.
As the legal profession, are we?
Thank you for that question.
How well prepared are we to embrace online dispute resolution?
So, allow me to give an example of what is happening in Kenya. The judiciary, I think the last 2-3 weeks, issued some notice that there will be almost like mobile courts that will be accessible through centers that are managed by the public service. In Kenya, it's called Huduma centers. And according to this notice, anyone can walk into a Huduma center in Kenya and do a number of things. You can file your case in that Huduma center. It means you don't need to go to court to file. You can register new cases. You can get issuance of summons to appear, notices to appear. You can retrieve court orders through those centers without going to court. Of course, there's an upheaval among the lawyers because we are like, no, this is encroaching on lawyers' territory. This is likely to allow quacks to join the profession without the relevant qualification. And to a large extent, I agree with the court file, the matter filed before court to stop this so-called online court. One of the main reasons for stopping the implementation of the online digital court is because of lack of public participation. But what am I saying? I would like us to know that we are not going to stop the technology from moving forward. There are generations now that do not know how to live without an iPad or a phone. Online dispute resolution to that current generation is something that is easier to them than us to understand. As a matter of fact, Previously, before the surge of technology used in dispute resolution, a lot of arbitrators was like, this cannot happen. We can't have a matter and use documents filed online and rely on those documents filed online and have a matter completed online. We can't. It will distort everything. We can't cross-examine online. We all know now that we are doing all those things online. So therefore, what am I saying? We must adapt to the technology. And what I'm proposing, or my premise right now, is that we have not moved as a legal profession in the entire East Africa fast enough to catch up with technology, which covers the area of the legal profession. What we need to do is to be vigilant to know what are the emerging areas of dispute resolution. For example, if someone can set up an entire system to receive complaints and resolve them online without the intervention or knowledge of lawyers, one has to ask, in that jurisdiction, is there any breach? Because I know in some countries, non-lawyers are not allowed to interpret even a contract. What are the guidelines for those operating systems for resolving disputes online without, without any regulation? You know, it's unregulated. What is it that we can do to ensure that we have regulations to find out what is happening and secure the space as much as possible for lawyers? What are the rules that we can put in place to match the technology that will enhance access to justice that we cannot do away from? All right. So I believe we are not moving and being as vigilant as we ought to encompass all the possible areas that we need to look at in terms of what are people doing online with disputes, how do we get involved, how do we know whether they are breaching data protection laws. And so we need to have rules that embrace technology and are continuously abreast as to what is happening and emerging technology, because technology changes every day. And therefore, that's just a challenge that we need to have. We can't stop it, we can't block it, but we can put legislation in place to protect our profession, as well as enhance and create more space for people to practice in. Whether you're young and whether you're old, we have the skills to resolve the disputes. You should be able to do it. And online dispute resolution offers such a system more expeditiously. Thank you.
Thank you so much, Eunice, for that elaborate response. Thank you for the attendees who are putting questions in the Q&A section. And Eunice pointed out really some of the challenges that are being faced. And in that regard, we shall look at one of the anonymous attendees' question. That is the anonymous attendee says, technology is welcomed in all fronts. My question is on mediation. Conducting mediation virtually is very challenging. How do mediators ensure that online mediation is as effective as the usual personal engagement with the parties in dispute? I'm going to ask Mr. Ochen to pick up that question. And as you address that question, really, you can tell us generally some of the challenges or drawbacks that we should be prepared for when we integrate technology into dispute resolution. Over to you, Mr. Ochen.
Thank you, Agatha. Eunice, thank you very much. You're making our work very, very easy because you're loading quite a bit of information, which is very useful. Madam Moderator, just allow me, before I forget, for the benefit of this discussion, I'm picking this from Eunice. Allow me cite for you 3 examples, and this will help us formalize, in our minds, appreciate better what we're talking about.
Please go ahead.
Eunice reminded me on the issue of ethical conduct. The issues of liability arise there, which is part of the challenges that we are dealing with, issues of data protection. I do not know if any of the participants online works with a law firm, an African law firm called ENS Africa. About a year ago or two, they were doing a transaction and there was some email correspondences. This is the South African branch. So somebody hacked into the emails and was able to tap that information. And when payment was being made, redirected the payments to be addressed, to be sent to a particular bank account. And the client lost money. An ENS was fined to pay that money. It's an actual case. If you Google, you'll see it. That is what we are dealing with when it comes to virtual hearings or ODR, whatever name that you call them. That's a real case. But also, it is important that for purposes of ethical conduct, we can look at and borrow from the IBA guidelines on ethical conduct, which is very, very important. The other second example I wanted to give, I was having a chat with Justice Chiriawire, and why am I bringing it? So that we can actually relate practically. This is a very wide subject. This time is not enough for us to break it down. So what happens is that there are three different levels of this interaction between technology and arbitration. The most comprehensible one is the one where we're spending most of the time, where parties and arbitrators make use of tools that are available online, electronic tools for purposes of supporting the procedure. Yeah, I'll give an example that I wanted to give, that the judge went to the US, they booked a hotel online, everything online. So when they got there, the charges, they wanted to move. Let me just say they wanted to move to another hotel. The receptionist could not attend to them. So he told them that, you know what, can you file your complaint online? And so they had to do that because she said she didn't have the right to clarify or to resolve their dispute. So quickly they put in in most of these online services, you'll find provisions for comment sections and the rest. So they put in and say, you know, we want to remove the pace at which that, if you've interacted with technology at that level, the pace at which they type, you know, it is not a human being. It's an artificial, you know, going into artificial intelligence at the back of the computer. So it wrote back and asked for reasons. They gave their reasons. After a back and forth of exchange, it allowed. And then it sent a notification. The receptionist was able to allow them leave without really being penalized by paying. That is how that works. The second stage, in summary, is the stage of full development. This is where there's creation and use of platforms for this ODR to facilitate dispute resolutions. These platforms aim at resolving disputes with all the advantages that come. Fast, efficient, fast. An example would be the EU rules on ODR, the 2015 rules when they're developed between, like my sister Eunice did say, a lot of these online tradings that are going on, they have also developed their own system. So that system has its own generated, where a notice of a claim is triggered, an administrative tool, a tech-enabled negotiation starts, and then an algorithm is developed, which will generate suggestions for parties to choose. You choose a particular suggestion and the dispute is settled there. If that is not settled, then it goes for appointment, for example, of a third party to resolve that dispute through arbitration or whatever it is. And now, for example, we have systems like CodeLegit, we have JAMS in the US. They are built on a distributive ledger where you have blockchain technology, where people are scattered all over the world, and it's basically scattered on the internet. And that system automatically appoints an arbitrator for purposes of handling your disputes. Then the third stage, which is very important, is the stage of artificial intelligence. Eunice did mention there's a lot of data mining that is ongoing. So it is important that we abreast ourselves as practitioners about issues of, we have ChatGPT, we have legal bots. Systems have been developed where they just generate case laws. In fact, for us in legal practice now, or arbitrators, you're asking yourself, Is it cheaper to hire an associate or to invest in the best software of technology for purposes of, because it will review agreements, commercial agreements of 1,000 pages in a matter of 5 minutes. It will do so many things. So these are the real challenges that we're facing now. So that is the last level. So that is just to give you an understanding. But going to the question of mediation, mediation is basically the difference between, let me start from the difference between a mediator and arbitrator. An arbitrator can make a binding decision between the parties. A mediator only facilitates settlement of that dispute between the parties. So the role of a mediator there is only limited to facilitation using best mediation skills for purposes of resolving the disputes between the parties. So it is so much driven by the willingness of the people, of the parties in that dispute to be able to I'm going back to the charts to find the question, particularly that was asked about mediation. Eunice, sorry, not Eunice, the moderator, Agatha, what was the question again? Sorry, I got interested into these other aspects.
The question on mediation is, how do we mediators ensure that online mediation is as effective as the usual personal engagement with parties in disputes?
Oh, thank you. I think it still comes down to the same. If it is an online mediation, that means we're using the same tools. We're using the same tools, for example, that apply in arbitration. So just ensuring that we are using safe tools. We've put safeguard measures in place to ensure that the mediation process is well facilitated for that personal engagement to take place in a dispute. But also taking the parties through the mediation processes in line with the principles that they have to watch out for in a mediation process would be very useful for that particular aspect. Thank you.
Mokua, you're welcome. My co-moderator is online and he will ask the further questions. Please, our attendees continue to use the Q&A section for questions. And some of the questions have been answered in the live session, but also some of them are being typed right into the answered part of the Q&A section. So let us continue with this insightful discussion. Over to you, Mokua.
My apologies, my internet dropped, but I have been listening in for quite a while. Now, my question would be, now this is not part of our predetermined questions because I do not know what you've tackled and what you've not, but my question would probably go to all the panelists, particularly my learned senior Lumalas. There is a website that has been developed by a colleague of ours who is a lawyer called Utatuzi Center. I do not know whether you all have heard about it, but it majorly deals with mediation and arbitration in the online spaces, and it is tailor-made specifically for that purpose. So my question would be, are there other platforms like this one that are tailor-made for online dispute resolution mechanisms, and how best can the young lawyer harness these systems, both for training and also for maximizing their potential in this space? Thank you.
Thank you for your question, Mr. Mokua. Utatuzi Center is one way to show every young practitioner that you do not need, you need to trust in yourself to be able to go out there and just do it. A lot of income is now generated online. Like when you open the Utatuzi Center site, for example, you see that there are several resources and there are several services he proposes to offer. You know, he says he can offer mediation and other dispute resolution services. Now, in terms of what is out there, perhaps you are not here, but Rita gave an outline of several other centers. I can, there's one I really needed to mention. There's a gentleman who has developed a site, and through that site, he has been able to get a lot of work online. I'll try and remember what it is called, but there are many. There are so many online. Rita had mentioned some of them. And he is one of the pioneers in online dispute resolution. What did he do? Him specifically, he used to work for a retailer, you know, one of those retailers, and eBay specifically. And he saw the potential of online disputes because you have people who don't know each other, you have apparels that are being transported across the nations. So how do you go about that? Now, he set up, when he left eBay, he set up an online resource website and center and advertised his services. In fact, he went back to his former employer and said, I can actually take this portfolio, I can be able to resolve these disputes. And some of them, they are resolved without any intervention of a third party, okay? What am I saying? I'm saying that online platforms offer the opportunity of an even multi-door way of resolving disputes. You can have a site where you invite parties to choose whichever method they feel would best resolve their dispute. You can allow them to negotiate directly through your site. You can allow them to pick a mediator online virtually, you know. You can allow them to pick an arbitrator virtually, and sometimes you can have disputes start and end without any human intervention. But online dispute resolution does not mean sometimes you do away completely with humans. We have seen the case where use of online reliance, too much reliance of online dispute resolution, including cases and analysis, have led to suits against parties, you know, because sometimes the information being put together by AI is not infallible. It can be wrong information. So it doesn't mean that you take your mind for holiday when you start using online applications, for example, to resolve your disputes. But like I said, there is need for young, particularly lawyers, to get involved in app development. Who are the young people who are developing apps? How can lawyers who know what they need more as primary dispute resolver? I know that ADR and arbitration is not only for lawyers, but the work of lawyers is principally dispute resolution. So we are best placed to know what application can best suit my needs. And you can actually invest more into learning. What is there to learn about dispute resolution online? How can I start my own? Which business can I go for? Which companies can I target in terms of corporates? What difference can I bring to them? Because there are very many benefits of online dispute resolution. You cut down on paper. You reduce the high volume of transaction. You cut down on costs of travel, etc. And you see, but then you have to get a platform that is better for you, because we all know the trouble with Google. And you have to ensure that you have a legislative framework that will not let you end in with the unnecessary legal suits. So the legislative framework is important in ODR. And I think internationally, the UNCITRAL, the United Nations Commission on International Trade Law, is working together with the UN to harmonize law with respect to online dispute resolution, so that there'll be more cross-border commerce that is seamlessly being resolved. And this is an area that we really need to get interested in, I must say. And like I mentioned earlier, 60 million average disputes resolved online by only one company eBay. So that's a great potential. Some of this business should come to our local dispute resolvers in East Africa. So we need to have the interest and tap into it. I'm not sure if I'm talking to myself or.
No. We are following.
Thank you so much, Eunice, for that.
If I'm talking to myself.
No.
We can hear you, senior. You can proceed, Agatha.
Can you hear me?
Proceed. Yes, I can hear you. Proceed, please. I can hear you, senior.
Okay. I just wanted to say she has brought out some of the opportunities available for young lawyers. There's opportunities in app development because you know what challenges and you know what you need actually as a lawyer. So thank you for that. Please, we are moving to the Q&A live session. If you have a question, like Catherine, you can put your hand up. But we are going to ask our panelist Rita to just, in summary, tell us some of the challenges. There's a question right there from George Muwanguzi. He's saying, how good is our connectivity in Africa for lawyers, in particular young lawyers or small firms, to fully handle ODR or ADR proceedings online? Rita, please, you can answer that question and as well as highlight some of the other challenges that might come as a result of ODR.
Thank you, Agatha. So in order to handle ODR fully online, there are a number of things that have to be in place. Like Makua has just said, most of the other countries and other jurisdictions are working on codification of the laws. There's no regulatory framework in place specifically for ODR. And the only thing that is being used right now is the ancestral technical guidelines on the use of ODR. So at the moment, okay, in Uganda specifically, what is happening is that some aspects of ODR are being incorporated into ADR. You use technology to resolve disputes through mediation or through arbitration and all other, the other forms of alternative dispute resolution. So to say that you can use ODR right now at the moment 100% would be a little bit tricky. I'm happy to hear that in Kenya, you already have a platform that's, that has been domesticated and is working okay. I haven't come around any platforms for Uganda specifically. I am only aware about the international platforms that are in place. There is one that's called ODRI, ODRI. The attendees can look into that. It's a multi-party online dispute resolution. Maybe just to say that these platforms, even though they're not yet here, they're going to get here, because we are working there. The technology is going to catch up with us if we don't catch up with it. So, and ODR would be nice because then you have a platform. You just log onto the platform and then it gives basic inquiries. What's your issue? What other documents you want to rely on? And then it gives you an opportunity to invite, you just send a link to invite another person, the respondent, to come and appear. And then it also gives you an opportunity to invite a mediator if you want, or you just resolve the issue between the two parties yourselves. So I think fully 100% it's not possible at the moment. It will be in a couple of years, but right now it's not possible, but it can be incorporated in other dispute resolution. Now, in terms of the general concerns, there are a number of critiques, obviously, about technology and the use of online dispute resolution. What comes to mind to begin with is the issue of the scope. There's an argument out there that what scope, what kind of disputes should be handled under ODR? What kind of disputes are easier to handle under ODR? And because it's been successful for e-commerce related disputes and small contracts claim and
debt recovery, because in New York, for example, they premise their platform on debt recovery. I mean, if you don't have a defense, you can't input aspects of your defense in the platform, it automatically cuts you out and then they proceed to the next stage. So the complex and the cases that have an aspect of public interest, then those cannot be handled under ODR. So there is need for codification to set out an exact scope for the kind of matters that should be handled under the system. And maybe the other concern is cybersecurity risks, but that has already been discussed. I will not belabor to repeat that. What we struggle with here in Uganda also is the issue of digital divide. Some of the practitioners have refused to accept that the technology is here. They prefer to do things in the older ways. They prefer to have paper copies of every document. They prefer to see the judge, you know, as opposed to having an automated system decided for you by some AI on a platform. So that's a real issue when it comes to increasing ODR here in Uganda. And then obviously the financial concerns, we cannot forget that technology is quite expensive. These platforms are not free, even if young lawyers come out here and collaborate with tech people and personnel, they need funds and, you know, investments. And these are some of the developing some of these softwares and systems requires a lot of capital to invest in. So that's also another concern that has to be considered. And then the issue of the regulatory framework. There are no specific laws, you know, so all Ugandan laws allow for ICT to be integrated, but there's no specific code for ODR. There's no framework, there's no scope, there is no committee that's going to advise on how this should be incorporated. So there's also an issue when it comes to the regulatory purview. And then, and this is also important, there are socio-economic concerns, but there's also an issue of internet. I mean, you cannot use technology fully and maximize the benefits without having proper access to internet. As at 2023 in Uganda, for example, the internet usage is at 24.6% only, meaning more than 30 million people did not access internet last year. So how many people are going to access these services? And how are we doing in our bid to pursue access to justice? Another concern that comes to mind. So yeah, basically there are some of the issues and criticisms on adopting technology into dispute resolution. But if we can come up with solutions to that, I greatly believe that the advantages of technology, they greatly outweigh the disadvantages that are associated with it at the moment. Thank you very much.
Thank you, Ms. Makelema, for that insightful response. I think now we will allow Mr. Milton to answer the next question. Lois Mwangi asks, how do we create effective agreements that secure digital trade secrets or tech startups that seek venture capitalist help?
How do we?
He asks, how do we create effective agreements that secure digital trade secrets or tech startups that seek venture capitalist help? You can also look at it from the perspective of documentary evidence in light of the digital signature, so that we can handle those two questions in one link for purposes of time.
Okay, thank you. Just allow me go back a bit. The earlier question that you asked, I just want to add some more insight.
Feel free, sir.
Thank you. My senior sister Eunice did justice to this, but I would just like to add that it is very useful, because there's no way we are going to participate in this digital or online dispute resolution processes without understanding how these processes work. So young lawyers need to interest themselves and gain knowledge and be knowledgeable into these app developments. The advantage that we have as lawyers is that with our legal knowledge, you're able to guide the app developers so that at the end of the day, the app passes the legal test, for lack of a better word. For example, I was part of development of, I sit on the National Building Review Board. It's a building regulator here in Uganda. So we were struggling with issues of corruption and the rest when it comes to approval of building permits and what and so on. I happened to learn quite a bit in that process of the app development. So we came up with something called the Building Information Management System. And in this system, a user, a developer can apply and actually obtain a building permit without ever having a human-to-human interface. And my role, or our role as lawyers, in light of what Eunice was saying, is that with our knowledge of the law, we are able to guide the app development process. But in return, you're also learning. And you also get to distinguish yourself. But most importantly, that knowledge to ensure that the app complies with the legal standards that are available. For example, driving it home to aspects of arbitration. We did talk about what is important is that whatever tool or whatever module or forum that you're using that is digital in nature, to ensure that at the end of the day, the final arbitral word will not be set aside. For example, some of the criticism, my sister Rita has already talked about them, but also aspects, what is very clear is that the way these digital systems work for dispute resolution is that sometimes they appear very restrictive. There's no proper interaction, limitations to do with cross-examination of witnesses and what and so on, notwithstanding the advantages that come with it. So it becomes very, very important that you understand this, and as you're participating in that process, you're able to, you have a lot of value to offer the app developers, and then that will also help you acquire a specialist knowledge that you can actually use, because arbitration per se is not just, you must have some specialized knowledge that you're going to help arbitrate over. We've seen a lot of shift, and a lot of things are happening in the metaverse. Most entrepreneurs, the big, large multinational companies are tech companies, and they want privacy. They are the ones who are developing all these things and online dispute resolution tools. So it is important that we get to appreciate how AI works. I remember of last year, the first robot lawyer, you know, some lawyers, some big law firm in Chicago sued the first world's robot lawyer. And this is a pushback from us lawyers, because the suit was that the lawyer the robot does not qualify under the definition of a practicing, for relation to our jurisdiction, a practicing advocate, because it did not have a practicing certificate for that matter. But for how long are we going to continue being in that? You know, very soon we are going to be overtaken. For some jurisdictions like Kenya, you're slightly ahead of us. So it is important that we appreciate how AI works. It is very important to understand blockchain technology. In Uganda, the central bank is not yet recognizing Bitcoins. We've seen some systems for dispute resolution online that automatically distribute, appoints an arbitrator. You must be listed as an arbitrator who understands these things. So those are some of the spaces in the future that you need to look at and see how you can have a foot ahead of the others. The other thing, lastly, is the issue of digital assets. These are intangible assets, and there's a lot of dispute being resolved on digital assets. So it is important that we understand these aspects very, very well. Those are some of the opportunities, and I thought I should share. But going back to the question, the question that Sai, you've asked. Where is it? I need to find it. How do we create effective agreements that secure digital trade secrets for startups that seek venture capitalist help? In line with what I've been discussing, an effective agreement is the one that, for lack of a better word, the one that will pass the legal test. and secure. I mean, here we are talking about, when we talk about digital trade secrets, we are talking about issues of data privacy, cybersecurity, which we've touched a lot about. But to answer the question in short is that this agreement will be effective if you take care of these aspects and let the parties own up to them as well. That will also protect you as the lawyer who is facilitating that agreement. But of course, I should mention that when it comes to venture capitalists, sometimes it's about negotiating power. Sometimes because we are disadvantaged from the continent, from the region, that when it comes to negotiating with capitalists or multinationals, we have a bit of a weaker bargaining power. But of course, you have to ensure that the agreement is not skewed one side. You have to protect interest of your particular party. My time is up. Thank you.
Thank you, Mr. Milton. I think Agatha
Thank
has
you so
something to
much,
say.
Mr. Ochen.
Thank you, Mr. Milton. Agatha has something to say.
Yes. I just want to recognize the attendance of the chairperson of the Kenya National Commission on Human Rights, Ms. Roslyn Odede, this afternoon. As we continue with the Q&A, I would like to ask Catherine Victoria to unmute and ask her question directly. Catherine, are you there? Okay, as she comes, there are some more questions that need to be answered.
Agatha.
Someone. Yes, please.
I think someone, it's the ICT department that should unmute her.
Mokua, are you there?
Yes, I'm there. I'm saying.
Okay.
I think it's the
Let's work on
ICT
that.
department. I'm saying.
Go ahead, Mokua. Go ahead, Mokua. We shall unmute them. Just let us answer the questions in the Q&A as we try to unmute Catherine and Victoria to ask their questions. Over to you, Mokua.
Thank you. Yes, DM asks, what are the enforcement mechanisms of autonomous decisions, and what examples of laws are there under international arbitrations on the enforcement of these decisions? I believe what this speaker is asking is in kind of arbitration where there are multi-state actors and there is a decision, how are such decisions enforceable, given that they involve multiple jurisdictions? Now I would invite maybe Melanie Senior Malas to speak to that.
Thank you. I have attempted already. I've put in a response. I don't know if it can be viewed, but basically what I'm saying is that if you are having an online dispute resolution, even if it is a trans-border or transnational, enforcement mechanisms depend on the nature of the dispute. Right now, we all know that internationally, we have a convention that was signed in Singapore, known as the Singapore Convention on Enforcement of Mediation Settlement Agreements. Under this convention, if there are parties that are mediating a dispute, doesn't matter the nature of the dispute, and then they agree and they have a settlement agreement between them, then you can enforce that mediation agreement in the country that you have chosen as parties to have it enforced. So, for example, if it's a domestic matter happening here in Kenya and you have gone through a mediation, it is an autonomous decision because you've done it independently, you know. So the settlement can be filed in Kenya. We file the agreement in court where parties are not complying, and obviously enforcement is only coming up because parties are not complying. Then you can prepare a miscellaneous application and you file in court, and that agreement will be enforced, and the order coming therefrom will be like any other court order. Similarly, in arbitration, an arbitration is guided, but as we said earlier, arbitration only comes into play where parties have in agreement agreed or consented to having a dispute resolved by arbitration. And therefore, depending on where we are, we heard about the Arbitration Act in Uganda, we have one in Kenya. You can then choose rules. If you have chosen the Nairobi Center for International Arbitration rules, it means that if you need to enforce that arbitration, then you go to Kenyan courts. And this is why we need effective court systems that understand this online dispute resolution methods or arbitration and mediation, and that can quickly support enforcement of an arbitral award or a mediation settlement. If you go to courts in a system, if you choose a system where courts are not, they don't understand arbitration or they don't support enforcement thereof, then you're in trouble. And that's why we say arbitration and mediation are always better methods to resolve disputes. Because if you know that Ugandan courts are better and you have a dispute with a party from Uganda, then you choose to have the support of Ugandan courts to enforce your agreements. Otherwise, enforcement will be done like any other dispute. You choose a seat if it's in arbitration. The seat means the courts of that country you have chosen. If it's Nairobi, are the courts you will be using to support that arbitration process. So I believe that answers the question. I have typed a bit of it for parties to read.
Asante sana Malani Senior. I'm informed that all the speakers who have raised their hands have been enabled to speak. So all you need to do is to unmute yourself and shoot your question. You can direct it to all the panelists, or you can choose a specific panelist whom you want to answer your question. Thank you. Catherine, you can go. Then we can do Victoria next. Catherine, you can hear me?
Mr. Makua, as you're waiting for Catherine, I could say something in addition to what my sisters said.
Yes, please. Yes, please.
All right, thank you. Thank you. Eunice is spot on. I just want to add something small. In as far as enforcement is concerned, of course, we're talking about enforceability of this award. The procedure, she has already nailed it, the registration, and it is enforced like any other court decree. But I think also, before you get to that stage, it is very important to look at, when you look at enforceability of this, of awards arising from this virtual hearing or any other hearing, what happens is that once an arbitral award, for example, is issued, there's going to be a scrutiny of the award and the arbitration agreement, because the process of registration, for example, under our laws here, when you're registering under the Arbitration and Conciliation Act, which is the same as for our Kenyan sisters and brothers, is that when you register this award, you must attach the award. It has to be certified. You must also attach a copy of the arbitration agreement. And it is very important that you look at the grounds for setting aside an award, which are contained in ours is Section 34. For international arbitrations, you have the New York Conventions, where several states have ratified it. And therefore, if you're one of the member states, then you enjoy recognition and enforcement of an award in any of those countries. So it is very important that one of the key reasons why these awards may not be enforceable or set aside for that matter is the aspect of party autonomy violation. And let me relate it specifically for virtual hearings. If the arbitration agreement does not expressly say so, I do know, of course, there are enabling laws that allows virtual hearings. But the principle of party autonomy is so strong that if one party, for example, does not want to engage in the virtual hearing and the other one wants, and the arbitrator uses his powers and chooses to go ahead with the virtual hearing, the arbitrator must ensure that, for example, the other party has been given an opportunity, to participate in that process. But most importantly, to safeguard the award from being set aside, it is important that that particular procedure of virtual hearing is well documented and incorporated as a party agreement, so that it is protected for purposes of enforcement, and that equality has been done. So it is very important that that's what I needed to add that. But for registration and enforcement, you look at sections 35 and 36. But yeah, thank you.
Thank you. Thank you, Mr. Milton. I am informed that Louis Mwangi wants to ask a question. Yeah, I think he addressed a question that he believes was not satisfactorily answered. Louis, if you can raise your hand so that we are given powers to speak, or the rights to speak. After Louis, I think we can then close the Q&A session and also close the meeting. Unless there is any other burning issue or burning question from the members.
Mr. Makua, what is that question that we didn't do justice? Maybe you can repeat it so that we...
Yeah, he has just sent me a text message, and I am asking him just to shoot it online just now. Mr. Mwangi, you can raise your hand so that you are given the rights to speak. Yes. Yes, you can unmute yourself now from your end.
Hello, sir.
Welcome. We can hear you now. You can speak.
The question was, hello, can you hear me?
Yes, we can hear you, sir.
My question was, how do we create agreements that are able to secure startups that are coming up so that they don't get to be taken advantage of by the venture capitalists when they're seeking for investments? And also to ensure that their trade secrets are not taken up by maybe where you are coming up with a startup and it is small, but it has a big ability to have a shift in the marketplace. And then maybe a big startup company, maybe a big tech company comes and takes over your idea. So how can we be able to come up with good agreements that can secure their trade secrets and also their small startup companies? Thank you.
Thank you. Even as Mr. Milton answered the question, we also look at the post implication of arbitration in association with young startups. Even
Mr. Makua.
Yes.
I believe this question ideally shouldn't be for this particular session. Yesterday, the East African Law Society ran, I think I attended, there was Professor Kakos and someone. I feel that this question is more of intellectual property protection between a developer that is developing this app that needs protection against an investor who is coming to take that startup. So I would say that I'll just answer as a lawyer that much as I'm not an expert in that area. Earlier on, I thought the question was within the context of the virtual hearings and so on and ODR, but it's a question of coming up with because every kind of agreement in a specialist areas has key critical clauses that have to be included. So for purposes of these agreements for startups, it's important that that particular agreement has relevant clauses that provide protection to the developer. For example, the issue of recognizing that the developer is the one that is coming up with this idea, it is his idea. And in the event that the capital venture, the capitalist is coming to take that, there should be due consideration for that particular. But what's most important is that recognition, and depending on what level it is, if it is a very unique idea, then definitely need to register for purposes of protection. I'll leave my colleagues to take that on. Thank you.
Thank you. I would have wanted you further to add to your very comprehensive response, the cost implication of arbitration agreements, particularly in young startups. You realize that arbitration is not that affordable as it would seem. And how do you balance arbitration agreements, especially between startups and more established entities, particularly now these capitalists? Thank you.
Maybe I can, is it a question I can answer or?
Yes, please. Yes, please.
Yeah, allow me to just go back to what Mr. Louis, who still has his hand raised, was talking about. So this is in the realm of intellectual property, you know, trade secrets, particularly undisclosed trade secrets. You have a trade secret, you don't want to disclose it, and you are supposed to get into a partnership with an investor who's coming to invest in your startup or app. You're developing an app for ODR. You don't want this to be disclosed. So basically, many jurisdictions do not have even proper laws to protect undisclosed trade secrets. But we are many countries, and I believe all East African countries are members of the World Trade Organization. And the World Trade Organization, I can ask Mr. Louis to read a bit, has an agreement on trade-related aspects of intellectual property rights. They're normally called TRIPS. But all in all, when you are bringing in an investor, just have a proper agreement with them and agree on profits and how the money is being invested and something like that. So just get a good lawyer. That's what I would say. In terms of arbitration is not suitable for all disputes, Mr. Mokua. I must say there has been I know an advocate called me the other day and was complaining about an arbitration where they were trying to get an award or an award of 2 million, and the arbitrator was asking to be paid about 900,000 in legal fees, maybe 1.2 million in legal fees. So that's why I'm saying you have to go to school to understand arbitration. If you have an arbitration and the amounts involved are not high, and unfortunately, drafting of agreements is very important. When you are drafting an agreement, please go to the dispute resolution clause. Do not choose arbitration if the amount is low. And if the amount is low and you have chosen an arbitration, before you proceed, and that's why skills in arbitration are important, agree with the arbitrator to cap the costs. You can say, this is a dispute of 1 million or 800,000 Kenya shillings, for example, or $800. Agree with us from the beginning that you will resolve this dispute and you will resolve it online. We'll only use documents and we will only pay you not more than $200 or $300 because of the quantum. So you really need to know that capping of costs is allowed in arbitration. But if you don't have the skills, then you'll go on with an arbitrator who is paid maybe the minimum of 20,000 an hour. As you know, if you're in some of these institutions, that's normally the rate, 20,000 an hour. Maybe you're a young arbitrator, 7,500 an hour, 10, 15 or 30,000 an hour, and then they have done the hours, so they're entitled to their fees. But it doesn't mean you can't negotiate even at that point, but it's better that you cap the cost before, or you choose a different method of resolving the dispute. Thank you.
Thank you. Thank you, my learned senior, for such insightful conversation. You have something else to add, Mr. Milton?
Mr. Makua, I would love to, not in this session, but another session, I've really enjoyed participating with Eunice. If there's another opportunity, I would. She's very hands-on. But let me just ride on what she has built to try and also add on the issue of cost, because I didn't answer the issue of cost. She put it very, very clearly. So what we've seen, because doing the arbitration agreement per se, by the technical definition of what is an arbitration agreement, it can be as simple as an email, one line saying that in the event that we have a dispute, we shall go to arbitration. And it is in writing, so that passes the test. So that will be an arbitration agreement. So what am I trying to say? That the arbitration agreement itself may not be very expensive, but the consequences of choosing arbitration, like Eunice has clearly said, you must have a threshold of the nature of the subject matter. It should be above a certain amount of money to go to arbitration. Secondly, as she has correctly put it, the clauses in there. For example, I'll use an example of Twin Towers here in Kampala. There's a case where there are two actually. One, it's a local project here locally, and then there was a dispute resolution arbitration. The dispute resolution was talking about arbitration, but the parties chose ICC to be done in France, and the laws. Arbitration is confidential, so I'll not give you the accurate facts. The seat, the laws are the laws of England. They're the ones who are supposed to be used. Now, here comes the complexity that relates to costs. It's a local project here. You want to take arbitration in Paris, the cost involved, because by design, ideally, by the time they were signing the agreement before COVID, it was largely physical appearance. So think about the costs of the ticket. You're going into a foreign jurisdiction. You need experts in that foreign jurisdiction, legal experts. Big law firms will, even Nairobi here, big law firms will give you a fee note. First, pay a minimum of this amount of money, maybe $30,000 or 50 or 20,000, whatever it is, just for an example. If you can't afford that, that will become a problem. So the choice is very important. Where do you want this arbitration? Where is the seat? Is it institutional arbitration or not? In another example, for example, at the time of filing the notice of arbitration, when you're doing institutional arbitration internationally, there is a deposit that you must make. If you don't make that deposit, the clock ticks and your arbitration will be in abeyance if you've not paid that money. Then they will do for you an estimate based on the subject matter, throw in a counterclaim there. You're talking about a dispute growing. What you thought was a dispute of $1 million, it is $5 million. And an assessment will be made based on that for you to pay fees. The next thing they're asking you, pay $200,000. You're a contractor, they've already pushed you out of business. You have money you're claiming in the arbitration, but you can't get it. That is a perfect example of the consideration of costs when you're coming into this arbitration agreements and the rest. And of course, earlier on, we talked about registration. We have a repo, I've remembered, for purposes of registration, which takes care of a certain jurisdiction for protection. For the other question of IP, thank you.
Thank you, Mr. Fred. And I will now take this opportunity to invite all the speakers to take 1 minute each to give their final remarks before we can close the session. I'll start with Ms. Rita Nakalema. Senior, you can take the floor.
Thank you so much, Makoa. This has been a very insightful session. It's a lot to learn about arbitration and the future, in using technology to resolve disputes. As I conclude, there was a question that was specifically directed to me from someone who wanted to know how this ODR will be used by most of the other people in Africa who are below the poverty line, and yet their disputes can be resolved online without incurring expensive court costs. I just wanted to say that dispute resolution, when you're choosing a platform or a method of dispute resolution, it's not a one-shoe-fits-all. kind of scenario, you have to look at different factors that go into that. So it's not that everyone should use ODR or ADR or court, but for people who cannot afford to use the platform, there are other ways of resolving their conflicts. We have small courts that are used to by different people as well here in Uganda to resolve matters that are below 10 million and all that. For you to go for ODR, both parties should be able to have access to the platform, to have access to internet, otherwise it would not make sense. In conclusion, I just wanted to say that technology is really a good thing for dispute resolution. And I would like to encourage other young lawyers out there to maximize the use of, the ICT machines that we have, and to make sure that we use it for the good of the people. But also let us not lose sight of, human values and commitments and feelings while participating in these dispute resolution processes. It has really been a great learning experience, and I hope to go out there and learn more about ODR and see how I can incorporate that into my own personal practice or my law firm's practice, and see how we can all work towards the promotion of access to justice for all the people. Africa. Thank you very much.
Thank you, Ms. Nakalema, for the wonderful closing remarks. I would invite Ocean Milton Fred to also give his closing remarks briefly.
Mr. Makua, it's Nakalema.
Nakalema.
Well, I'm instructing myself for that matter. It's Nakalema, but you've given it a good try. But you're going to buy a coffee for misspelling her name. Anyway, my parting shots. That was on a light note. Technology is not a menace to arbitration. It can and should be used to enhance aspects of arbitration that are criticized today. It's coming in to put in fillers and make the process more efficient when it comes to arbitration. Secondly, like we've seen in the discussion, there's no going back. The effect of technology being rolled out is that it doesn't go back. Yesterday we had the Bar Bench Forum, and we have the ICMIS system, which is the electronic case management system for our local courts. And the chairperson that steers that committee was assuring us as lawyers that there is no going back. They just want to improve it more and more. Why am I using that example? That when technology kicks in, there's no reverting back because we get comfortable with it. So it is important that as practitioners, we grasp the use of these virtual tools, like my sister Rita has explained. Let's find them, let's use them, let's interest ourselves, because that is the future. The biggest businesses today and biggest the future areas of practice that are going to be lucrative are within the digital space. Fintechs is one of them. Aspects of cybersecurity, online trading. We have Jumia cutting across, Amazon and the rest. So it is important that we need to look to that future and acquaint ourselves. At a policy level, we need to move as lawyers and push for amendment. And I think Eunice did talk about this, of our local legislations. We need to be more proactive, to be inclusive of the use of these technologies. But most importantly, we must equip ourselves with the knowledge to be able to adapt. The field is open to the academia, to app developers, arbitral institutions, practitioners. We are not going back. So as a parting shot, it's time to go to work, time to think and rethink, to learn and to unlearn and learn any and all aspects of these virtual hearings to facilitate better dispute resolution. Thank you.
Thank you, sir, for the wonderful remarks. Now, my learned senior, Lumalas, can give you a parting shot before my colleague Agatha and Nancy has been corrected, gives us the follow. Thanks.
Thank you very much. I wish to thank the East African Law Society for inviting me. I'm very passionate about this field, as you can tell. I want to thank you for putting us together, Ms. Rita, together with Mr. Nakalema. I hope that's how you say it. I hope I got it right. Now, if there's something that the members need to also allow me to do is acknowledge the presence of the new sheriff in East Africa. We have my sister Awasum Mispa, who is the manager of Chartered Institute of Arbitrators, Rwanda. I think she's online, just to acknowledge her. It's good to see her following this online and making time for it. Now, if there's something we must learn from the online dispute resolution platforms is that the young lawyers, the young practitioners ought to know that now more than ever, they have the tools to start earning a living by going online and by starting their services and advertising those services and offering them. What am I saying? You can open an online kiosk and call it anything. Mokua, Manyara, ODR, East African Center. You can advertise your center to corporates, to banks, that you will resolve their disputes by mediation online and you'll effectively reduce their costs, among others. Well and good, particularly where there are cross-border disputes involving corporates in East Africa. That is a welcome approach, and I'm sure you will get business. However, don't forget to follow what you need to in terms of appropriate ethical standards. Keep confidentiality, integrity of evidence of the documents you have to deal with, your own competence and diligence. You have to ensure that you are diligent and are not discriminatory, that you protect your clients' data and you keep learning and improving. Otherwise, you will be smoked out if you are lacking in competence. Other than that, well applied information technology systems are actually changing the landscape. You know, when you have AI, even if AI knows I have tried to Google East African community, everywhere I go on all my handsets and social media handles, you'll see that they read us, they know what we are doing. And so artificial intelligence and, machine learning have been utilized and are being utilized to do a lot. For example, if you have a lot of data to analyze, they can do it faster than humans. And therefore, they do it faster than arbitrators. You can use them to arrange your documents. You can use them to assess the risks in a matter. You can use them to even help you to arrive at a decision. But you know the dangers are there, such as the decisions that have been set aside. An arbitral award has been recently set aside because it was found out that the arbitrator used machine learning and AI to support the process, and he got some misleading information in there in terms of precedents and the like. So basically, it doesn't mean that we like I said, we leave our brains behind. We move forward with them. We analyze what we are dealing with. And I think that is the future. ODR is the future of ADR and arbitration, actually. So thank you so much for this opportunity. I look forward to interacting with you in future. Thanks.
Thank you very much. Thank you very much, Melanie Senior. Thank you much, Ms. Nakalema. Thank you very much, Mr. Milton Fred Oshen. Now, we'll take this opportunity to invite Agatha to give us a vote of thanks as we close the session. She can officially close the session. Thanks as we close the session. You can officially close the session.
Thank you, Mokua. And once again, thank you to our panelists, Eunice, Ochen, and Rita for such an insightful and wonderful session. You all did the topic justice, and as young lawyers, I'm sure we've taken all the advice that's been given, all the knowledge that's been given to better prepare ourselves for the future, the ODR. And I just want us to take just a few things they've mentioned. Be competent as a young lawyer. Be competent, network with Eunice, with Rita, and really we want to thank Rita as a young lawyer for standing out and being passionate, and you know, she's well conversant with all these technological tools, and we are learning, and thank you, Rita, for that. Let's attend conferences. Let us offer ourselves to serve. And I think Eunice mentioned that if you offered yourself to be her understudy on an ODR, she would be willing to, you know, accommodate anybody that approached her. So once again, I want to thank you to even our attendees who are still online. Thank you for the wonderful questions that you raised for our panelists. And once we organize another webinar, we expect you to join in and to be as passionate and to ask as many questions as you can. As the Young Lawyers Committee, we are committed to continue bringing experts in different fields to ensure that as young lawyers, we are equipped and we are competent as legal practitioners. Thank you, East African Law Society. Thank you to my co-moderator, Mokua, for taking the mantle to co-moderate. And once again, thank you to everybody. Have a lovely evening.
Agatha.
And see you next time.
Agatha.
You're free to leave. The meeting has come to an end. Thank you.
Agatha.
Mr. Milton, before we conclude, would you like to speak, to say something?
Yes, please.
Yes. I've noticed on our I've noticed one of the attendees, Dr. David Bachibinga.
Yes, please.
I was just saying that.
Before we conclude, would you like to speak, to say something? Yes. I've noticed on I've noticed
Hello?
one of the.
Please go ahead.
I was saying that I noticed on the list of attendees is a very distinguished gentleman, Dr. David Bachibinga. He's a law scholar and a professor of commercial law here in Uganda. He has widely published. It's a pleasure, I believe, to have him on call. Thank you.
Thank you so much for mentioning such a person. Thank you for tuning in all over where you are, in Africa, in Rwanda, in Kenya, Uganda, South Sudan. We have Cameroonians here. Everybody, thank you so much for making the time. Thank you for our panelists. I think now we can leave. Thank you so much.